Retomamos el programa. Ahora vamos a tener la única presentación que es a distancia. No ha podido venir Eric. Estoy viendo que está ya conectado. Eric, can you hear me?
Yes, I can
Yeah,
hear you.
okay.
Can you hear me? Okay, I
Yeah,
think it works.
okay.
Fine.
So Eric Steinhauer is the head of the University Library of the FernUniversität in Hagen, Germany. And he has a background in law, theology, philosophy, political science, and education. Steinhauer focused on academic rights law, cultural memory institution, and data protection in the digital area. He teaches at various universities, and he has been involved in legislative process on these topics. He served as a spokesperson for the German Research Outbound Committee and was previously involved in the development of the German Research Foundation Code of Conduct. And now, when you can start for us, we are waiting for you. So,
Okay, thank you very much for your kind introduction. I hope everybody can hear me. So, talking about law after coffee break is a really good idea to snooze a bit off. And I want to be not so boring and to mention a lot of legal details. And let's see, where is my presentation? Yeah. And the title of my presentation is really big for roughly 20-25 minutes. Challenges and strategies for libraries when it comes to open science. Well, I think it is more about awareness and showing you some background when it comes to digital content. And this is very important if we want to develop our libraries as institutions for open science. We should not forget the legal issues. Yesterday, we had a wonderful talk, this presentation from Sweden, and I searched the National Roadmap for Open Science of Sweden, and then I found this to provide researchers with affordable, adequate, and secure infrastructural services compliant with the applicable regulatory framework, Data Protection Act, and everything else. So the library is responsible for some safe legal framework. And in the Open EU strategy, we heard this. One mission is the integration of emerging technologies, including AI. I want to add emerging technologies and include them, but then we also invite all the legal problems associated, for example, with artificial intelligence, and there are lots of legal problems. So when it comes to open science, one thing is, maybe it is trivial and obvious, open science is digital. This changes everything when it comes to law. We are moving from books, from printed material to content. And when we are moving to content, there's a lot of talk about technologies, platforms, software, devices, fundings, and everything else. But what about the legal consequences of this shift to the digital environment? So you see here two people just reading. Of course, the boy is reading in a printed book, and the girl, I think she's reading some ebook or whatever, on her display. It's just reading. But when it comes to law, both are living in completely different environments and spaces. So take a book, and I have here beside my desk this nice book, and I open this book. What does it mean when it comes to copyright? Nothing. It's just opening a book. And then I am reading. Is this something which affects copyright? I don't think so. It is just reading. But when it comes to the same book, but now in an electronic format, what is opening the book? Maybe you see some PDF icon or something else, and you're clicking on that icon. But what is happening then? The book is open, of course, but this means some data is coming from some server to your device and is stored there and is displayed. And everything what is done here is reproduction. And when it comes to reproduction, we are in the field of copyright. And if you're turning a page in a digital, an electronic book, it is again a reproduction. And when you're going to make this book available to a broader audience, this is making available to the public. In the old times, we bought books, printed books, then we have our library room. The book which we have bought is our property, our tangible property, and we can decide which person is allowed to borrow the book, to read the book, whatever. But the publisher or the author is not involved in that because we have decisions on our property. But when there is no tangible item and only content in networks, then it is all about reproduction and making available to the public. And here we are in a completely different environment when it comes to law. So a bit legal background. This is here a European directive. I don't want to talk about national copyright acts because we have different national copyright acts in Europe, but we have a common framework. And this common framework are some European directives. And one of the very important directive is this directive from 2001. I think it's Bronze Age of the internet or so, 2001. It is still valid and still very important. And this is so-called Information Society Directive. And here you have our common European framework when it comes to copyright. And you see here 3 so-called exploitation rights. You see the right of reproduction, the right of making available to the public, and the right of distribution. When it comes to printed material, the right of distribution is, we say, exhausted when you buy the book. That means the publisher, the author, cannot decide what to do with this item you have bought because this is your tangible property. So no copyright issues when it comes to printed books. But if there's digital content, there is no tangible item, there is no distribution in the sense of copyright, there's only reproduction and making available to the public. And here, even if you pay money for the content, there is no exhaustion. So you have some license contract, and then you can see in the license contract what you can do with the content, what is allowed. Can you share it online and how many people can read? And with every publisher, with every item, the license could be different. So it is very hard to decide what to do with the digital content. So it's not this easy world, this easy analog world. It is more complicated in the digital world. So what can we do? Again, here, the legal background. Exhaustion, you see this when it comes to tangible items, but this is not the case when we have digital content. We then have only exceptions or limitations in the law, or we have licenses. So this is the ground we have to stand on, and we have to know about when we are talking about digital content. What can we do with digital content is only that what is granted through an exception or limitation in the law, in the Copyright Act, or it is agreed in a license with a publisher or some other rights holders. So when it comes to exceptions and limitations, we have to look into the Copyright Act, and there maybe we find some exception which allows us to do something with digital content. For example, digitize older books which are no more available on the market and of which I don't know the right holders, so-called orphan works. Then I can do some digitization and other things. The talks in this conference, as far as I have seen them, were much about up-to-date publications. And when it comes to science and engineering, then we are talking about open science and open publications. We have newer publications. And we have a digital working environment, and everything is fine. But when it comes to the humanities, older material is very relevant. And when we would like to construct a really open digital working environment, we have to digitize a lot of this old material that and make this accessible. So we have to look into the law and see some exceptions or limitations. Otherwise, we have to negotiate and get some licenses. So exceptions and limitations on the one hand and licenses on the other hand, these are the two ways we have when we are asking, are we allowed to use digital content in an open way? So what are the consequences? We want to build a library service for open science, and we want to provide digital content. But to reach our plannings and our hopes and expectations, we need, on the one hand, exceptions in the law. Maybe we have them. If not, this is a political debate we should then do. And if there is no exception in the law, then we have to go to the licenses. And here, one very important model are the Creative Commons licenses. We can use for material which is not yet in the hand of big publishers. We have heard a lot about rights retention policies. This is the way, not to give your rights away, but to build a quite robust legal framework using Creative Commons licenses, so everything is quite easy manageable. This is fine, but there was one question, one very interesting question. What about Creative Commons license and training of artificial intelligence? What if I do not want this? So sometimes those licenses have to meet new challenges, and we have to seek some answers. So it is an ongoing challenge to have a good legal framework when we use licenses for open science. I just was copyright is very important. And I'm now in the field of legal debates for more than 20 years. And 15 years, even 10 years previously, it was only copyright we were talking about. And libraries were very strong also in this debate. But now personal data are also very important. We have this common European framework, the GDPR. And yeah, what about personal data when it comes to open science? What about digitization of newspapers? And you find a lot of names in this. And maybe some news are not very, very nice. And a person could come to the library and say, oh, please, I have here in the European regulation the right to be forgotten. Please remove that scan. What can we do? Lots of things. And we have personal data, but there's also just data. We have now this European data strategy, and we have a lot of European legislation, for example, Data Governance Act or older legislation like public sector information directives. There are some obligations what to do with your research data, making them available and under specific conditions. So we have to know all these regulations when we build, when we want to build open science services as a library. You see here the Data Governance Act. It's a quite new European legislation. And here you find, or you can find the FAIR principles. I think yesterday somebody mentioned also the FAIR data principles. And this is European law. And if there are research data produced with public money, we have to meet the FAIR principles, and making data accessible. It's also a question about the legal framework, under which conditions. Yeah, you would say, okay, legal framework is important. That's fine. Then we can ask the lawyer. The bad news is this is not the way how it works, because the lawyers very often do not know a very good answer. It's like moving your car in the traffic, and you are approaching the traffic light and you see the yellow light. What are you going to do? You can stop or you can accelerate and move on. And normally the lawyers say, oh, it's safer to stop. And a lot of questions we have when it comes to open science are this yellow light questions. It's not very clear what we can do. The thing is, we want to use new technologies. But if a technology is new, the legal framework, the written law, is quite old. And this law does not know this new technology. So we have to interpret the law, and we have to ask questions to the law. And if you are asking questions, you can ask 2 lawyers and you will get 3 answers. So if we want to move quickly forward with new technology, we have to be part of this legal discussion ourselves. The thing is, if there is no legal discussion, and when it comes to the courts and when there's some legal conflict, what are the judges doing? They're looking into the written law, and sometimes they will find nothing because the law is quite old. So they look into the literature. And it is very important that there is some discussion about how to use the law we have when it comes to open science and to open libraries. So we must be part of this discussion if we want to have good results. When it comes to copyright, this was very successful. But I think now when we have so much legislation in the data law, I see so little engagement from librarians and from people from this sector raising questions, asking questions, and solving questions, discussing solutions for our legal problems. But this is important to have this discussion with us when we are building an open science space, because nobody else will do this work for us. So what are the steps? We should identify the legally relevant areas of open science. And then we should see, okay, what is the situation? And maybe we can do some political work to have better regulations in the law. But otherwise, we have to discuss also these legal topics with lawyers, be active in publishing and raising these questions, to have, in the end, a really good discussion and a really good practice. I think this rights retention policy is some sort of this thinking, because when you have a very dogmatic approach, there are lots of questions. But what are you doing is some kind of risk approach. So it is more than, it is like a power play. So we have here the money, we have the content, you are the publisher, and these are our conditions. Okay, and let's see how far it goes. And this is a good way to do things. So this is my conclusion, and I want to share this with you. Please do not forget the law, no matter how interesting and compelling the new technology is, and how interesting the idea and the vision of open science is. Without the legal framework, you will have some nasty problems and not good results. Thank you very much for your attention, and I would like to have some discussion. We have a bit time, so please ask questions if you like, and I will try to answer if possible. Thank you very much.
Thank you very much, Eric. ¿Hay alguna pregunta en la sala para...? Sí. ¿El micro? Just a second, we are looking for the microphone.
Hi, thank you for your talk, Eric. I had a question on the sentence on secondary publication rights and the Universität Konstanz. Could you briefly comment on that one, please? Thank you.
As far as I know, we have no result. It is still at the Supreme Court. It's a constitutional court, and there is no result yet. The thing is, this okay, maybe I should explain the background, because not everybody knows what is this. We have in some legislation on the state level, you know, Germany is a federal state with a lot of states. On the state level, in the state Baden-Württemberg, where cities like Freiburg, Konstanz, Tübingen, Heidelberg, and so on are, we have in this Act for universities some provision. If you have the right to republish your work in the green way of open access, you have to republish if the work is funded by public money. And the law faculty of one university, this University of Konstanz, was against this regulation, and the faculty went to the court. One important step, the law, the University Act, says this obligation can be imposed by a university. So one university must do this on university level, and this University of Constance did this it was the one only university who did this. So the law faculty was against this, and they went to the court, and the court said, oh, it's a matter of constitutional law, but not when it comes to is there a right or obligation of open access. The question was very formal, because the court said, oh, this is regarding copyright. And for copyright, only the federal level is competent to do legislation, not the states. And with that question, they went to the Constitutional Court. And now the case is there for years, and there's no decision. Maybe one background, I think the people of the law faculty are the only people who are earning money when publishing with publishers. So they like their publisher. So if you are publishing a legal paper in Germany, you will have, I think, some 300 to 500 euros for one paper. So this is quite nice. So you like your publisher, and why this open access model? And there's also one difficulty when it comes to law. Law, of course, is a university discipline, but there are also a lot of authors there from practitioners, like lawyers, judges, and so on. And they are, especially the lawyers, they are earning money with publishing and also with the knowledge. So there is really a market for this kind of information. It is different. It is other. It is not so in the humanities, for example. So open access rules in this market are a bit different than open access rules maybe in the humanities. But the legal question is a really technical question. It is about who is competent to rule this. Is it copyright law, or is it just university law? University law, you can rule on the state level, and copyright law, you only can rule on the federal level. We hope that the Constitutional Court will also say something about freedom about academic freedom and open access, to have some orientation for our discussions. We will see. So everybody is waiting for this decision.
¿Una pregunta más en el auditorio? ¿No?